Back, it's wonderful to see everyone. It's my pleasure to introduce our first speaker for this morning, Professor Carter Snead, who is the William P. and Hazel B. White Director of the Center for Ethics and Culture and a Professor of Law at the University of Notre Dame. He is an internationally recognized expert in bioethics, and his research explores relating the neuroethics, enhancement, stem cell research, abortion, and end-of-life decision-making. He has authored in over 40 journals, he authored over 40 journal articles, chapters, books, and essays. His scholarly work appears in a myriad of publications, including the New York University Law Review, the Harvard Review Forum, the Journal of Medicine and Philosophy, Political Science Quarterly, to name just a few. He is also the editor of 2 book series for the University of Notre Dame Press, Studies in Ethics and Culture, and Studies in Medical Ethics. Professor Snead teaches law and bioethics, health law, torts, and constitutional criminal procedure. In addition to his scholarship and teaching, Professor Snead has provided advice on legal and public policy dimensions of bioethical questions to officials in all 3 branches of government and at the state and federal level. He has also served on several intergovernmental fora. Prior to joining the law faculty at Notre Dame, Professor Snead served as general counsel to the President's Council on Bioethics, chaired by Dr. Leon Cass, from whom we will be hearing later today. He was the primary drafter of the 2004 report, Reproduction and Responsibility, the Regulation of New Biotechnologies. In 2008, Professor Snead was appointed by the Director General of UNESCO to a 4-year term on the International Bioethics Committee, a 36-member body of independent experts that advises member states on bioethics, law, and public policy, and the only bioethics commission in the world with a global mandate. His lecture this morning explores the battle for human dignity in public bioethics. Please join me in welcoming Professor Carter Snead.
Thank you, Jess, very much. It's a great honor to be here this morning. Thanks to John Cavadini and to Jess for putting this wonderful program together. And what they do at the Office of Human Dignity and Life Initiatives here at the University of Notre Dame is absolutely indispensable, and we are grateful to have them doing that very important work. And thank you all for coming early in the morning to hear my talk. I understand that yesterday was a great deal of discussion focused and nested in theology and philosophy. This is going to be oriented towards a more practical domain, namely the domain of law, a particular domain of law, public bioethics, which I'll define for you momentarily, and its contours will become clear as we march through the discussion. So dignity as a concept, as a legal concept, as you may have already heard, and as you certainly will hear later, is pervasive in international law. 37 constitutions since 1945 integrate dignity as a juridical concept. Prominently, the Basic Law in Germany has a very famous human dignity clause declaring that human dignity is inviolable and to respect and protect it is the duty of all state authority. Earlier than that, of course, 1947 Universal Declaration on Human Rights, very famous articulation recognizing the inherent dignity and equal and inalienable rights of all members of the human family is the foundation for freedom, justice, and peace in the world. However, in American law, human dignity is not a concept that has much direct juridical purchase. It's used instead as a second-order principle invoked rhetorically to shore up support for analogous concepts, well-defined juridical principles that can be invoked directly with legal force. For example, equality, liberty, justice, and privacy. Now, my talk today, what I aim to do in this conversation is to discuss the conflicts in the usage of human dignity as a legal and political concept in a particular species of American law, namely American public bioethics. And so, to do that, I'll proceed in the following way. First, I will give an account of what I mean by a legal concept. It's fairly straightforward, but I think it's important to spell it out at the outset of my remarks so you can get a sense of the direction of the rest of the talk. I'm going to lay out a very brief roadmap of the competing uses of the terminology human dignity. I'll give you a very brief survey of the limited way dignity has entered American law and policy, and then I'm going to drill down into the context of public bioethics and explore a basic struggle between two different, very distinctive conceptions of human dignity that really do animate a great deal of the discourse in American public bioethics. And the struggle between those two things also reflects a very different moral anthropological set of premises about human flourishing and even the boundaries of the human community. And then I'll conclude with some very brief thoughts reflecting on the status of human dignity as a juridical concept, as a legal concept in American public bioethics. So let's start then with the very basic question of what do I mean by a legal concept? Well, normative principles, legal concepts, enter the law in a variety of ways. They can be explicitly invoked in the positive law enacted and enforced by the political branches of government. So, for example, in our Constitution, our written Constitution, it's positive law, we have legal concepts like due process. In the Fifth Amendment and the 14th Amendment to the United States Constitution, we have a principle of due process under law, which both has procedural elements as well as substantive elements, which we'll talk about going forward in a little bit. More vaguely, or more broadly, if you will, in the Fourth Amendment to the U.S. Constitution, we have the legal concept of reasonableness. The Fourth Amendment, which declares that there shall be no unreasonable searches and seizures of an individual's person, property, or effects. Reasonableness is a live concept that judges and lawmakers spend a great deal of time thinking about, unpacking, and applying to actual concrete cases and problems. Legal concepts also emerge through the process of judicial construction, not simply by articulation and drafting in a positive form, but also in judicial opinions. So, for example, in the common law of torts in the United States, we have the legal concept of the reasonably prudent person. In Griswold versus Connecticut, the very famous case from the 1960s in which the court declared that there was a fundamental right to access to contraception, the court nested that decision in a right to privacy, which they inferred or uncovered from the procedural language of the Due Process Clause, along with several other provisions of the Bill of Rights. So those are examples of direct legal concepts that emerge either through positive law or through decisional law and are applied directly with real legal force. Legal concepts also emerge indirectly as rhetorical principles. Rhetorical principles that are invoked to add moral force to legal arguments made by or to officials in the judicial, legislative, or executive branches of government. And this is really where we find human dignity in American law. It's not a principle like equality, due process, privacy, reasonableness. It's instead a very forceful rhetorical concept which is applied to these more well-defined legal concepts, as you'll see in a few moments by way of example. But before we turn to the actual examples of American law and the way that this legal concept has emerged, let's talk a little bit about dignity itself to sort of set the table to understand ultimately the dichotomy between the two forms of dignity that are at war with one another in American public bioethics. So as you probably heard yesterday, historically the word dignity has had different connotations and different meaning. In classical antiquity, dignity referred to worthiness for honor and esteem, mostly associated with excellence. Judeo-Christian tradition, dignity really refers to the irreducible and alienable worth of all persons by virtue of their creation in the image and likeness of God. In Kantian moral philosophy, inalienable dignity emerges in virtue of rational autonomy. In modern bioethics and applied ethics, philosophers like Ruth Macklin associate dignity with a person's worthy of respect by virtue of their capacity to choose or act freely, to pursue and construct their future unencumbered by limitations. So dignity has a lot of different faces. You can see you've got dignity as excellence in sort of antiquity. That's Maximus from the movie Gladiator, in case you guys were wondering who that was. Well, it's Russell Crowe. It's not actually Maximus. It's an actor playing Maximus. This is an aristocratic gentleman where dignity sort of transferred from those who actually demonstrated and modeled excellence to those who received the designation of dignity by virtue of their place that they were born into in a particular aristocratic structure. This represents sort of Ruth Macklin's vision of dignity as autonomy and will and freedom of expression, and this, of course, represents dignity as an intrinsic, inalienable element of all persons, regardless of their circumstances or conditions. It's associated with well, among other things, Judeo-Christian tradition. So the rough dichotomy, then, of dignity that will do a great deal of work in the context of American public bioethics momentarily is dignity as an intrinsic property possessed equally by all human beings merely by virtue of their membership in the human family, which obtains regardless of accidental characteristics like size and strength and wealth and independence or social standing, actions or circumstances. It's a pre-political concept. It's not conferred by the state. It's not taken away by the state. This is the notion of intrinsic dignity that I'm sketching out here. And it entails respect for the equal worth and minimal baseline of moral respect, care, and forbearance. Which means that if a person has dignity, and everyone has dignity under the conception of intrinsic dignity that I'm sketching out right now, and there are different approaches to that within moral philosophy and politics. But if this is basically the idea that dignity itself is something that's intrinsic to all human beings and demands and requires that we extend moral concern and basic protection to the law to people as a result. So there are various theories of intrinsic dignity that obviously I've already talked about. The Imago Dei, that is the notion of equidistance from God, confers a certain kind of dignity. Gil Meilander probably talked about that yesterday. It's something that he's been quite articulate about. Kant held the view that we should always treat persons as an end and never merely as a means. And then I leave it to scholars of Kant and other philosophers as to whether that extends to those with diminished capacity for rationality, since rational autonomy seems to be the triggering event for human dignity under this framework. But that's not my area of expertise. I leave that to folks who have studied the question more closely than I have. And then international instruments like the Universal Declaration on Human Rights and various foreign constitutions. They adopt what appears to be an intrinsic theory of dignity really in the wake of atrocities. After World War II, after the Holocaust, after seeing what base and atrocious and shameful and ugly things human beings are capable of, trying to recover a notion that everyone, without exception, has basic inalienable worth. Now compare intrinsic dignity on the one hand with a notion of contingent dignity. That is the view that the worthiness of persons depend on their capacities or their actions, their capacity for action, or even their actions that they take themselves to satisfy a predetermined set of criteria. Under this approach, certain actions, even certain kinds of lives, are dignified or not, or to greater or lesser degrees, depending on conduct or power. It's a property that ebbs and flows. It's not a consistent, inalienable, irreducible worth. It's a worth that depends on the individual, what he or she can do, and in some cases, what he or she does. A lot of theories reflect this principle of contingent dignity. The classical antiquity conception of dignity as excellence. Dignity is contingent on exceptional performance. The aristocratic notion of dignity really equates dignity with social rank. It's contingent on social status or title. Ruth Macklin and other modern bioethicists' conception of dignity as autonomy, which will play a large role in the dignity wars in American public bioethics, makes dignity contingent upon the capacity to exercise autonomous choice, constructing the future of the unencumbered self. And in this way, it's closely tied to expressive individualism and the moral anthropological premises that underwrite expressive individualism. Conversely, and this is important for public bioethics, lives that are marked by radical dependence and diminished autonomy are undignified. In fact, there are some thinkers and policy theorists and even policymakers who argue that people who really draw the boundaries of the community of persons dependent entirely upon the capacity to choose, the capacity to formulate and pursue future-directed plans. If you can do that, then you fit within the class of persons who are entitled to moral respect and the protection of the law. And if you can't do that, then you are not a person, pre-personal, if you're an unborn child, post-personal, if you're suffering from dementia, for example, and your life and your future depends on the goodwill or needs or interests of others. So, how about American law? In American law, the concept of dignity emerges, again, mostly as a rhetorical concept, underwriting other more well-defined legal principles, as you'll see momentarily. But it actually, the first instance of the word dignity occurs in Federalist 55. The commentaries that were published as a sort of guide to understanding the American Constitution, its structure, and its content. James Madison in Federalist 55 notes that the requirements for membership in the federal judiciary are meant to ensure the work of the courts be conducted with utility and dignity. So here you see that dignity is a kind of principle ascribed to institutions at first. It's an institutional principle in its first iteration in American law. You can see the same thing as late as 1999 in the case Alden versus Maine, in which the Supreme Court wrote, "Federalism requires that Congress accords states the respect and dignity due them as residuary sovereigns and joint participants that is consistent with their status as sovereign entities." So again, an institutional principle, institutional status. States have dignity. Courts have dignity. But gradually, there was a transition in American law from institutional standard of valuation to a personal standard of valuation. And a handful of state constitutions adopt dignity as a juridical principle in their state constitutions. Louisiana has a dignity clause. Montana has a dignity clause. But more prominently emerged as a rhetorical concept in judicial opinions, legislation, and executive actions. But again, almost always underwriting a more well-recognized and directly applicable legal concept. So for example, you see in criminal law and procedure the word dignity emerging to underwrite and to defend and to shore up, as a rhetorical matter, the legal concept of privacy. So in the Fourth Amendment, we have Supreme Court opinions like Schmerber versus California, which say that the overriding function of the Fourth Amendment is to protect personal privacy and dignity against unwarranted intrusion by the state. What we're talking about here is warrantless searches and seizures of an individual's person's property or effects. Similarly, we had a case called Winston versus Lee involving the compulsion of the subject to undergo surgery to remove a bullet, and a case called Roshan involving forced vomiting by a criminal suspect to produce some evidence that he had swallowed. And the court here said that reasonableness, the concept of reasonableness, which, as I mentioned earlier, is a live, active, directly applicable legal concept, is one factor in evaluating reasonableness of a proposed search or seizure is the extent of the intrusion upon the individual's dignitary interests in personal privacy and bodily integrity. Excuse me. Similarly, in the Fifth Amendment in criminal procedure, you may know from television that your Fifth Amendment contains your right against compelled self-incrimination in a courtroom or in a custodial interrogation. In these cases, Miranda versus Arizona, which gave us the famous Miranda warnings, the court said the constitutional foundation underlying the privilege against self-incrimination is the respect of a government, state, or federal must accord to the dignity and integrity of its citizens. So it's a kind of freedom from coercion, which the concept of dignity shores up and supports. Same thing in a later decision, Justice Breyer in dissent, U.S. versus Balzas, said that the reason that one of the core normative justifications for the privilege, the freedom against self-incrimination, is the unseemliness, the insult to human dignity created when a person must convict himself out of his own mouth. In the Eighth Amendment context, which involves the injunction against cruel and unusual punishment, human dignity is invoked as a rhetorical concept to anchor and shore up the principle, the directly operative legal principle of retributive justice. The idea that, the idea that cashes out in the death penalty context that punishment has to be proportionate to the culpability of the individual and the gravity of the crime. And to exceed proportionality, to punish someone disproportionately, is a kind of transgression against cruel and unusual punishment. And the concept of human dignity has been invoked in a variety of cases to try to defend this principle of proportionality, and it is included opinions that are forbidding death eligibility for certain kinds of convicts, including people who are under 18 at the time they commit their crime, people who are held in inferior conditions, where in medical care of prisoners, for example, falls under a particular standard, or degrading conditions of confinement. These are considered disproportionate forms of punishment that are illegitimate under the Eighth Amendment, and the concept of human dignity has been invoked several times to, again, anchor this principle of retributive justice. In legislation, positive law, on behalf of crime victims, the concept of human dignity has been invoked to promote the more well-recognized and applicable principles of fairness and privacy. And you see this a great deal also in the civil context, in anti-discrimination suits. In a very famous dissent in the Korematsu case in which the court actually upheld Franklin Roosevelt's program of internment for Japanese Americans, Justice Murphy invoked the concept of human dignity en route to making a very strong argument against discrimination. Anti-discrimination principles and inequality and the positive good of equality, again, are recognizable principles in American law that have direct applicability, and human dignity was used as a kind of rhetorical device to promote that. Same is true in the civil rights cases of the 1960s. Dignity used to shore up the concept of equality and against discrimination, both on racial grounds and grounds of sex as well. And then we saw later on, in this century, the concept of human dignity being invoked by Justice Kennedy as part of his argument, rooted in a kind of anti-discrimination norm against discrimination on the basis of homosexual conduct. Lawrence versus Texas is the case that overturned Texas's law criminalizing homosexual sodomy. And Justice Kennedy, who generally orients his arguments by the sort of the pole star of liberty, invoked the concept of dignity as well. Even in the context of voting rights, the equality of each voter has been framed in terms of dignity as well. Now, I will say, before I turn to the main focus of the remarks, namely the concept of American public bioethics, there is an interesting new development that we saw last year involving the use of dignity as a juridical concept, again by Justice Kennedy, again in the context of homosexual rights. In the case Obergefell versus Hodges, in which the court struck down all laws forbidding same-sex marriage and declaring that there is a right in the Constitution to same-sex marriage, the argument that Justice Kennedy makes, the jurisprudential claim that he makes, is situated in a sort of new good that he refers to as equal dignity. It's not liberty exactly, it's not equality exactly, it's a sort of hybrid of those two things, and in which he talks about equal dignity as the principal good emerging from the Constitution as a source of authority to invalidate all restrictions on same-sex marriage. And it's a little difficult to suss out what the contours of this are as far as Justice Kennedy is concerned, but one thing that's clear is it does seem coextensive with his earlier arguments about liberty and self-expression. And really what I think is driving his conception of marriage and his conception that the Constitution requires equality in marriage between same-sex couples as well as opposite-sex couples is this notion of self-expression, and that freedom, these liberties implicit in the guarantees of due process, extend to, he says, this is a quote from him, personal choices central to dignity and autonomy, including intimate choices that define personal identity and beliefs. So in this seems subtly different from the earlier invocation of dignity as a kind of anti-discrimination principle in the Lawrence versus Texas case that I mentioned a moment ago. In fact, this seems like something moving towards really almost Ruth Macklin's vision of dignity as autonomy, especially as they relate to choices that are central to personal identity and expressing the self, unencumbered by limitations. And this is going to be very interesting to see where this goes. Commentators, Lawrence Tribe and others, have already noticed this new usage of human dignity and wondering if a jurisprudence of human dignity is about to materialize or develop further following Justice Kennedy's line of cases. It's interesting because some commentators, pro-life commentators, have raised the possibility that, well, maybe this new emphasis on human dignity could give rise to the possible new protections to unborn children. Other folks on the left, Lawrence Tribe and others, have thought maybe that this new conception of human dignity will give rise to a broader array of civil liberties to disfavored minorities, transgendered, transsexual, and so on. So, but it's an open question right now as to whether there will be a jurisprudence of dignity emerging from Justice Kennedy's seems like a new iteration in Obergefell versus Hodges. So, all of this is by way of illustration that, with the exception of Obergefell versus Hodges, dignity in American law generally, again, is used as a second-order rhetorical amplifier for what are already well-recognized legal concepts such as equality, justice, fairness, privacy, reasonableness, and so on. So what about public bioethics? Public bioethics, first of all, it's important to say what I mean by public bioethics. Public bioethics is not merely theoretical inquiry and reflection about public matters. Public bioethics is actually a form of law. It's actually the governance of science, medicine, and biotechnology in the name of ethical goods. It is the work done by those organs of the state, whether they're judges or legislators or members of the executive branch, whether it be the President of the United States or the head of an administrative agency, in which they actually adopt rules, regulations, legislation, judicial opinions that have binding and coercive authority on all of us, again, in the name of advancing a particular ethical good in the context of biomedical science, biotechnology, or the practice of medicine. It is actually, in a very significant way, the operationalizing of moral principles in the coercive fabric of the law. And that doesn't have to mean that it's all negative. You can have positive versions as well. So you can have positive inducements in the area of public bioethics, like federal funding for embryonic stem cell research, for example. That's an example of the government not restricting something, but rather signaling its support and favor for it, and then imposing a kind of coercive tax framework, extracting money from taxpayers to go towards this priority that the government has chosen. So that's an example of positive regulation where it's inducing and rewarding certain kind of behaviors. And the negative form we're all more well familiar with, which is simply its most restrictive form, criminal prohibition. So a criminal ban on human cloning would be an example at the opposite end of the regulatory spectrum. That's just to say that regulation is a very fine-grained apparatus and can signify a whole lot of different meaning, symbolize a great deal of divergent meaning emerging from the government. The government speaks when it regulates, teaches, it shapes people's conceptions of the good, it reflects conceptions of the polity regarding justice and the common good. But again, for our purposes here, when I say public bioethics, what I'm talking about is the governance of science, medicine, and biotechnology in the name of ethical goods. We're talking about law. We're not talking about inquiry and reflection. So in American public bioethics, as I mentioned earlier, there is a real struggle, a dichotomy between the intrinsic principle of dignity, which I sketched out earlier, and the contingent version of human dignity. And you see it dramatically in the language of politicians, in the language of legislation, in the language even of Supreme Court precedents. What are some examples? So let's first focus, how has intrinsic dignity been manifest in American public bioethics, the conception of intrinsic dignity? Well, there are basically 4 areas where intrinsic dignity, and I'll come back to these 4 areas where it's also the case that contingent principles of dignity have been mobilized and applied as well. Embryo research, abortion, end-of-life decision-making, and then public health, and I'll focus specifically on the President's malaria initiative, just very briefly. So basic embryology, I won't actually go through this. We can talk about it in the question period if you want, but one of the key factual premises underlying the use of intrinsic dignity as a concept in embryo research is the biological fact of the emergence of an organism at fertilization and the sort of continuity of development from fertilization throughout the variable gestational stages. This is a matter of agreement. This isn't speculation. This isn't idiosyncratic. It is simply a fact, and every embryology textbook that is on offer recognizes that the life of the human organism begins at fertilization, and there are a lot of quotes, and we don't need to go through all of them. These are the basic seminal embryology textbooks, all of which reflecting this proposition, that the life of the human organism begins at fertilization. And from the moment of fertilization, you have a sort of unbroken continuum in which the individual organism moves through a variety of stages, changing in appearance, changing in capacities, but retaining its identity as the same individual organism. And this fact that the individual organism of the species Homo sapiens begins at fertilization, begins at conception, is an important fact anchoring the principle of inalienable dignity, intrinsic dignity that drives a lot of the law in American public bioethics. So that's a biological fact. The life of the organism begins at conception. The moral claim, which can be reflected in doctrines of the Catholic Church and also reflect the notion of equal justice under the law, which is embedded in our own Constitution and laws, is that it would be a grave injustice and in fact rank discrimination to treat individuals differently based on accidental properties such as how big they are, what their capacities happen to be, what their state of dependence or burdensomeness is, or certainly the esteem in which others might hold them, whether they're wanted or not. As the Church puts it in the following, it says that the entire span of life before and after birth does not allow us to posit either a change in nature or gradation in moral value, since it possesses a full anthropological and ethical status. That's the Catholic Church's iteration, but we see this exact same principle in notions of equality, equal justice under law, in American law and across the world, even if it's not applied perfectly to all members of the human family. So this biological fact and this sort of normative notion of equality underwrites a lot of the arguments in favor of, or rooted in intrinsic dignity in the context of embryo research. So you have, for example, Congresswoman Virginia Foxx on the floor of the U.S. House of Representatives making the argument that embryos are human beings, for reasons that I just sketched out, and should not be treated as research subjects. We would never kill to harvest body parts because of the principle of human dignity. We do not even do this with our most heinous criminals. We do not treat them as things. We treat them with dignity until the time they die. All human beings have profound human dignity. So you hear, in this context, in a deliberation, in a debate on the floor of the U.S. Congress, we have human dignity being invoked in service of the principles of equality and non-discrimination. Similarly situated people should not be treated differently, certainly, and being similarly situated in this context means being a member of the human family. Don't kill embryos, don't use embryos as research materials because it's an affront to their human dignity. Human dignity is intrinsic. It applies to everyone equally, regardless of their status, their biological status, their social status. That's what's reflected in this comment. And it was an argument that had legal valence because it was made in the context of this debate over federal funding for embryo research. President Bush in 2007 issued an executive order which prioritized and privileged those forms of stem cell research, pluripotent cell research, that did not depend on or incentivize the use and destruction of human embryos. He was focusing, for example, on techniques that produce pluripotent cells either from dedifferentiating somatic cells, as in IPS, which is the technique developed by Shinya Yamanaka in Japan and James Thompson at Wisconsin, where you can take a human somatic cell, a fully differentiated cell, and using certain genetic factors, dedifferentiate it or walk it backwards to where it obtains all the characteristics or virtually all the characteristics of an embryonic stem cell and can be used for the same applications in principle, or even adult stem cells, more differentiated than pluripotent cells. President Bush wanted to prioritize and underscore that in his administration and under the federal government and the administrative state at which he was at the top, the President of the United States sits at the top of the administrative state in our federal system of government, that he wanted to prioritize those species of stem cell research that didn't require the use and destruction of embryos. And why was that? In a document, in an executive order which has the force of law, he elaborated on this argument and made the point that it's critical to establish moral and ethical boundaries to allow the nation to move forward with medical research while also maintaining the highest ethical standards and respecting human life and human dignity. So he invoked human dignity explicitly in its intrinsic sense as an argument for the radical equal treatment of all human beings at all stages of development. Also in the context of abortion, you see this concept of intrinsic dignity emerge. Again, on the floor of the U.S. House of Representatives, in the debate in the run-up to the Partial Birth Abortion Ban Act of 2003, which was a law that banned a particularly gruesome and controversial form of abortion, usually done at very late stages of pregnancy. Representative Ross Leighton, after describing in graphic detail this procedure, she points out, this is a barbaric act that is a grave attack against human dignity and justice, and it must be banned. Life is a gift, and it must be embraced and respected at all stages. So what we see again here in the context of abortion, in its intrinsic form, human dignity as a concept emerges to shore up the more recognizable concept of equality. She's talking about equality and non-discrimination, the sort of gravest form of discrimination. Discrimination between who counts and who doesn't count, who has human rights and who can be destroyed for someone else's purposes. But she invokes human dignity in its intrinsic form to do that. At the other end of the spectrum of life, we see intrinsic human dignity invoked to shore up, again, principles of equality and non-discrimination. In 2005, you may recall the case of Terry Schiavo. It was a protracted struggle about the appropriate treatment of a woman who was profoundly cognitively disabled. There was a dispute between her parents and her husband about whether or not she should have her artificial nutrition and hydration discontinued. There were serious questions about whether or not the courts in Florida had adequately taken into account the full evidentiary record as to what her wishes were. Her wishes were, in my judgment, pretty ambiguous. It wasn't really clear what she wanted, which means under Florida law, which mirrors most laws across the country, that the court you have to err on the side of life and do nothing. It's not proven by clear and convincing evidence that a person wishes to die under those circumstances. As a legal matter, you don't do anything. But in this case, in the Florida courts, the husband prevailed. The courts decided that the woman, Terry Schiavo, by clear and convincing evidence, wanted to discontinue these things, even though she couldn't obviously speak for herself at that point. Her parents contested that. And it gave rise to a whole series of legal wrangling. The legislature in Florida passed a law authorizing further investigation in the courts about what her wishes would have been. That was signed by then Governor Jeb Bush. Then that law itself became embroiled in litigation, which ultimately culminated in its invalidation by the Florida Supreme Court, which led the U.S. Congress to adopt a law providing additional avenues of inquiry into what her wishes would have been, and under a sort of civil rights rubric signed by President Bush, ultimately not implemented before she died of dehydration. But in signing the bill from Congress, which, by the way, interestingly, had the support of most of the voting members of the Congressional Black Caucus. It included support by a variety of others in liberal and progressive, Ralph Nader, Joe Lieberman, Jesse Jackson. They all supported this law for Teichaibo. When he signed it, President Bush pointed out, those who live at the mercy of others deserve our special care and concern. It should be our goal as a nation to build a culture of life where all Americans are valued, welcomed, and protected. Again, intrinsic human dignity applied. Now, same is true. He made the same arguments in his malaria initiative, which saved about a wide variety of lives in Africa and in the Caribbean. Every human life has inherent dignity and matchless value. Now, compare that, and I'll move through this quickly, compare that to the articulation of contingent dignity in American public bioethics. You see in embryo research a conception of graduated dignity, an ebb and flow. Certain people have dignity to different degrees depending on how strong, healthy, or mindful they are. For example, Janet Rowley of our own President's Council on Bioethics made the point that patients with serious illnesses can have their lives, the dignity of their lives, enhanced through the use of treatment by embryonic stem cells. Restoration of human dignity was a phrase that Mike Gazzaniga, also the President's Council, used for people who are seriously diseased and infirmed, and as an argument for embryonic stem cell research. In abortion, in Planned Parenthood versus Casey, again, you see Justice Kennedy talking about choices central to personal dignity and autonomy are central to the liberty protected by the 14th Amendment. So the choice for abortion is essential for human dignity because it opens the way towards free expression and pursuit of one's future goals. You see that also in dissent by Justice Ginsburg and Justice Stevens, the authority to make these decisions. Empowering decisions is an element of basic human dignity. And Justice Ginsburg, whose view has got a lot of traction now among legal scholars of a certain kind, is that the freedom to choose abortion is essential to a woman's dignity and autonomy because it allows the construction and pursuit of future goals on an equal basis with men. And then at the end of life, we see in the rhetoric of these decisions, dignity as associated with the freedom to choose against a life of dependence and suffering. Justice Brennan, in a dissent, wrote about people not wanting to live on a life sustained only by medical technology. Instead, they prefer a plan of medical treatment that allows them to die with dignity. Justice O'Connor, in a similar case in Glucksberg versus Washington, the indignity of living one's final days incapacitated and in agony is at the heart of liberty. The freedom to avoid those things is at the heart of liberty and autonomy. And Justice Breyer, very similarly, the same. And as I said, some theorists make even the definition of personhood contingent upon these capacities to conceive of and pursue future directed plans. Those who can do that are persons, those who cannot are not. Dignity is thus contingent on the possibility of autonomy for these theorists and policymakers. So, let me wrap up. The fundamental divide in public bioethics is between dignity as intrinsic, inalienable worth, which is invoked to shore up claims of equal protection under law for the vulnerable at the margins of life. Dignity, on the other hand, is, in the alternative, conceived of as the freedom to construct and express one's identity and to pursue future goals without unwanted limits. And operationally, it's invoked to anchor claims of liberty, to pursue and use the fruits of embryo research, to choose abortion as a mechanism of equality, and to select the time and manner of one's death. Dignity, again, even in this setting, is not a first-order concept. Now, we should leave for a later day the question of whether we need dignity as a first-order concept in American law, because liberty, equality, privacy, and even due process are relational goods. They depend on context. You can respect equality by treating everyone equally badly, for example. These relational goods don't speak to the problem of membership, whose good counts as part of the common good, doesn't talk about what is owed in virtue of human dignity, and so we might very well continue our thinking about whether or not we should have dignity, as these foreign constitutions do, as a formal principle which is directly applicable. And Avishai Margalit from Hebrew University underscored that dignity, unlike social honor, is not a positional good. It is supposed to be accorded to everybody, even to the one who is nobody, by the most universal common denominator of being human. So thank you for your attention, and we can have conversation afterwards. Jess, are there time for questions?
We have time for one question.
One question. Looks like
Conversation at the break.
Ricardo Calleja, you get the one question.
Thank you, Karen. As you know, I come from Europe, where we have dignity, and in Spain, dignity is also a cornerstone of the Constitution. But that doesn't solve the problem you just explained. So the problem is not that we have a formal concept of dignity in the Constitution. We have it, and we have the same debates about the true meaning of dignity. Which ultimately comes, I think, and I don't want to be too cynical, that dignity itself is a rhetorical concept, or a kind of, as Professor Walsh said yesterday, abbreviation for a lot of things that we cannot say in a short phrase. So, well, I suppose this is a continuous struggle, but I don't know.
So what now is your question? What do we do? Okay, that's a great point. So dignity can be, as we've already seen, in my explanation of America, you have people arguing that dignity requires euthanasia of disabled children on the one hand, and on the other side you have people arguing that dignity forbids embryo-destructive research. So this illustrates your problem, and this has led some people to say, oh, dignity is a stupid concept, it's vacuous, you can fill it with whatever you need, and therefore autonomy should be our concept. Well, that doesn't make sense because autonomy is equally vacuous. The issue here, it seems to me, and obviously this requires a lot more discussion and talk, I think the fundamental question is not these terms and concepts, but rather the moral anthropological premises that underwrite them. We have to sort out, first and foremost, what it means to be a human being and what constitutes human flourishing, right? Then we can supply further content to these normative goods like dignity and autonomy and privacy and so on. We have to get right, first, the question of what it means to be a human being, why it matters, and what we're made for. All right, thank you all, and we can talk more, I guess, if we have a 5-minute break. Talk to you soon. Thank you.